Hi, good evening, Nilesh.
Hi, hi. So you're all,
Can I just share my PPT and see if it's working well?
yeah, yeah. Great.
Yeah,
Let me
thank you.
join you as a host. Now.
So I just try whether it's allowing me to do that. No, it's not allowing me to do that.
So I'm also checking how to share things. Hello, afternoon, everyone. Welcome to our syllabus webinar once again by the Bombay Incorporated Law Society. Today we have Ms. Shivani Khanna speaking on the Insolvency and Bankruptcy Code. Uh, Shivani is a partner of FZB Associates since 2014, and she has been practicing as a lawyer and appearing in the High Court, City Court, and doing a lot of litigation and corporate work. She's also done certificate courses in IBC and in Arbitration and Conciliation Act from IMC. Shivani has also got a primacy charge most court competition for being the best speaker. So I'll now hand over to Shivani now, and she will take over. Okay, Shivani, you can take
Uh, Thank you, Nilesh. First,
over.
Nilesh, you're not audible. Can I start, Nilesh?
Yeah, yeah.
Yeah. Uh, Thank you. I first of all would like to thank BILS for allowing me to conduct this lecture on IBC law. Before we start studying what exactly IBC is, I would like to give you a bit of a background. Now, before the IBC actually came into force, there were several laws. For example, SICA Act, there was BIFR, there was Companies Act, all acts all over place. Now, what happened and what was the object of those acts was finally to wind up the company and close down the company. Hence, the need of an hour was felt that an exhaustive code should be enacted, where under one exhaustive code, there are all the laws which are built in. Now, example, a company as a living person, obviously it is a juristic person. What IBC aims at is to pump life into the company which is dying. That is done through a CIRP process in a time-bound manner. However, when you are not able to revive the company, it finally leads to liquidation, that is the corporate death. Now, for the purposes of this session, what we have done is that the presentation is divided into various parts. So the first stage will be your CIRP, the second stage will be the liquidation, third being the avoidance transactions, then comes the voluntary liquidation, fast track insolvency resolution process, and jurisdiction and other miscellaneous clause. For the purposes of this lecture, I have endeavored to give you the AIR citations. However, due to my inability to access the AIR journals, where it is not possible, I have given you the equivalent SEC citation. Let's start with the corporate insolvency resolution process. In order to understand the corporate insolvency resolution process, there are few concepts that everybody should be clear of. So the definition sections are contained in the section 3, as also in respect of the corporate debtor under section 5. What is a debt? Debt is a liability or obligation in respect of a claim which is due, and it is also an inclusive definition to include the financial debt and an operational debt. Now, this takes you to the next definition of the claim. So claim is a right to payment. Having understood the debt and claim, you have to be clear whether it is a financial debt or an operational debt. For a financial debt to come into play, there are few ingredients that has to be satisfied. So financial debt means a debt along with interest which is disbursed and in consideration of time value of money. So what do you mean by time value of money? Time value of money means the money actually in hand today has much more worth than the money that will be held in future. So for instance, a bank parts with the money and gives the loan. What is the consideration? What is the time value for money? The time value for money in that case is the interest component which is payable by the borrower. The financial debt definition is also an inclusive definition. It lists several items which is included in the definition of financial debt. However, I would like to emphasize on item F. Now, this is a all catching provision which says that the transaction, any transaction which has a borrowing effect, that is also included in the financial debt. There was an amendment done and explanation added whereby allottees under the real estate project, that is under the Real Estate Act, the RERA Act, were also included under this definition. I would also invite your attention to another item, that is clause I. Now this says where there is any guarantee given in respect of any of the above in items, in that case also it gets covered under the financial debt. In contrast to that, the operational debt is what? It is basically a claim in respect of supply of goods or services. It includes your employment dues, statutory dues. So this financial debt or operational debt has to be due by a corporate debtor. Corporate debtor is a corporate person which includes the company. Now we'll be focusing on the company as per your portion. This corporate debtor, this company has to commit a default in paying the debt, which is the debt due and payable. And in relation to the financial debt, it is payable to the financial creditor. In relation to the operational debt, it is payable to the operational creditor. Now, having understood these concepts, now which creditor files application under which section has to be understood. So where the CIRP process is being initiated under section 7, in that case, a financial creditor, either by itself or jointly with any other financial creditors, can file application under section 7. What is to be most importantly noted, the default may not really be in respect of the financial debt to the applicant financial debt creditor. It can be to any other financial creditor. Now this section was amended later, and there is another category that got included over here. So where a financial debt is in relation to any securities or deposits and they belong in the same class, or if there is a allottee in respect of same RERA real estate project. So they have to be either 100 creditors in the same class or in the same project coming together, or 10% of the total number of the creditors or the allottees, whichever is less, and they have to jointly file an application under section 7. As opposed to that, when it comes to an operational creditor, the delivery of demand notice or copy of invoice is a must. Now, when this is done, when a demand notice or an invoice is delivered to the operational debtor, to the corporate debtor, he gets 10 days to reply, to raise a notice of dispute. What is a notice of dispute? In this notice, in reply to the demand notice, he is going to inform the creditor of any pre-existing dispute or record of any suit or arbitration which is filed before the receipt of the notice. Or he can simply say that I have paid your debts. Here, see the self-attested copies of the bank statements or the email transaction, whatever record he has, so as to prove that the payment of the debt has already been done. If neither payment or notice of the dispute is received, by the creditor, then the operational creditor can file an application under Section 9. The third category is filing of applications under Section 10, that is when the corporate applicant files the application where the corporate debtor has committed a default. Now, the definition of corporate applicant, it includes the corporate debtor. It includes any other authorized person or a partner who's been authorized by virtue of a constitutional document to file any such application. It includes the person who controls the management of the corporate debtor. It also includes a person who supervises and who has a power of taking financial decisions for the corporate debtor. Having known who can file, now comes the stage of the filing of the application. So when an application is filed by a financial creditor, he has to annex the record of default. Now, this record of default is filed with the information utility. Now, information utility is a central agency. In layman terms, what happens is if I am a bank and I lend money to you, I will inform the central agency, the information utility office, that I have given loan to you. You default that in payment to me, any outstanding amount, any debt is due to me, that also gets intimated to information utility. So that record has to be annexed along with your application when a Section 7 application has been filed. And also the financial creditor has to name the resolution professional. As opposed to this, when a Section 9 application is filed by the operational creditor, in that case, the operational creditor along with the application will file the copy of the notice, the demand notice, it will file the invoice, it will file the affidavit saying that he did not receive any notice of dispute. He will also file other record evidencing the default, that is a certificate from the financial institution confirming that yes, there is an unpaid due, or a record from an information utility office, yes, there is an unpaid due. These are the evidence that he has to file along with the application. He may or may not propose the name of the resolution professional. When it comes to Section 10, a corporate debtor filing the application, in that case, it is necessary that the corporate debtor files along with the application the resolution which has been passed so as to initiate the application under Section 10. Now, along with that, the naming of the resolution professional has to be done under Section 10. Now, the adjudicating authority has these applications. The adjudicating authority has to satisfy itself that the applications are complete in nature. When it comes to Section 7 application, the adjudicating authority will satisfy that yes, there is a default that is done, the application is complete, and the named resolution professional, there is no disciplinary proceedings pending. In contrast to this, Section 8, the court has to do a lot more work. The court has to see whether the demand notice was actually delivered to the debtor. The court has to see whether notice of dispute has been raised or not, whether the application is complete or not, and whether there is an unpaid due. Now, in contrast to these two applications, under Section 10 application, the court will see whether the financial status, the financial records of the company has been annexed to the Section 10 application or not, and whether there is any disciplinary proceeding pending against the resolution professional. Having satisfied of these ingredients, adjudicating authority within 14 days decides whether to admit or reject the application. The admission of any of these application, it culminates into the commencement of the insolvency, the CIRP process. However, if there is any default, as in your application is defective, in that case, the applicant gets 7 days to rectify the defects in the application. The code also categorically specifies who cannot file application under 7, 9, and 10. So a corporate debtor who is undergoing any CIRP process, a corporate debtor having completed CIRP 12 months preceding the date of the application, if this corporate debtor or any of the financial creditor has violated the resolution plan, which was approved 12 months preceding the date of the application, corporate debtor in respect of whom the liquidation order has already been passed. So these are the four categories of the person who cannot initiate application under 7, 9, and 10. However, there was an amendment by virtue of which there was an explanatory note added that the aforesaid corporate debtors, however, can initiate the CIRP process against the other corporate debtors. Now let's look at the jurisprudence which has developed in respect of section 7 to 9. I will be, before dealing with the ratio, giving you in 2 lines or 3 lines what are the facts really about. So in this Mobilox versus Kirosa, they both had some subcontracting document agreement. They had a separate non-disclosure agreement. Now, Mobilox does not pay the payment which is required to be made to Kirosa, and Kirosa raises invoices. So the question arose when the notice is received. Mobilox says that you have breached the NDA agreement, and because of that, I am not going to pay you money. So when the matter came before the Supreme Court, the amendment was not in place under Section 8. So where it is mentioned that when a demand notice is received, the operational debtor has to either show a pre-existing debt, and the previously it read as and the record of suit and proceedings. At that point of time, the court said that and had to be read or, which now the amendment takes care of. There is the second most important thing, what did the court say? So where there is a dispute raised or the record of suit or proceedings are mentioned, it is necessary that this must be a pre-existing dispute or a suit or an arbitration which has been filed before the receipt of the demand notice or invoice. The dispute cannot be a feeble contention or a legal argument or a hypothetical or illusory thing. What adjudicating authority has to satisfy is that at least a plausible contention has been raised, which requires a further investigation. Having said that, the adjudicating authority need not go to a larger extent to say that whether the defense is likely to succeed or not. It just has to see whether a plausible contention is raised or not. There is another case of Mercury Bank Limited versus Shilpi Cable Technologies. Now, what had happened was the rights under the supply agreement was assigned to Mercury Bank, and this bank is a Singaporean bank. Shilpi Cable defaults in making payment. Mercury Bank files a Section 9 application. However, in the Section 9 application, the bank does not annex the certificate from financial institution which maintains the maintaining the accounts of the operational creditor. Here, the question arose whether it is mandatory for the creditor, the operational creditor, to annex such kind of a certificate. The court says that look at the provision of the Section 9. What does it actually say? It says that the certificate confirming the default, confirming the unpaid due. So the court says that it is merely evidentiary in value, and therefore it is not a mandatory requirement. The court also goes into the definition of the financial institution as also the operational creditor. So the operational creditor is the person to whom the operational debt is due. If you will now correlate and does not have an account with a financial institution which is registered in India, that does not by itself bar this operational creditor from filing